Good morning, and welcome to Gough Square Live. My name is Robin Kingham, and today I'm joined by Michael Coley, who's going to be talking about Part 8 of the Enterprise Act 2002 and civil enforcement. I'll be manning the live chat online, so if you have any questions, please do submit them using that function, and Michael will deal with them at the end. You can also email your questions to us directly if you like, at the address that I've uploaded in the live chat. It's goughsquarevl, that's Victor Lima, at gmail.com. Right, well, without any further ado, over to you, Michael.
Thank you, Robin. So the Part 8 procedure under the Enterprise Act has been enforced since 2003, and as many of you will know, it provides a civil alternative to criminal enforcement of consumer legislation. There were some amendments made to it under the Consumer Rights Act 2015, which introduced enhanced consumer measures and also made some changes to the territorial extent of the powers available to local weights and measures authorities. And some of those changes have beefed up the procedure as a means of enforcement and made it a much more viable tool in the enforcer's armoury in a wider range of cases. So today we're going to look at the procedural issues which arise and where some of the pitfalls are to avoid when seeking an enforcement order under Part 8. So starting with the pre-application period, in any case, the proceedings will start with the enforcing authority being made aware of a potential infringement of the relevant enforcer's legislation. And once the authority has decided to proceed on the Part 8 in respect of that infringement, there are three criteria which first of all must be met. And we can see those if you put up slide 1. So you can see that the three criteria are that the trader must have engaged, be engaging, or be likely to engage in infringing conduct. Secondly, there has to be harm to collective interests. And finally, there must have been a consultation which has failed to bring about the cessation of the infringement, or that consultation must have been waived. So we can take slide 1 down now. Dealing with those points one by one, these are the three crucial tests which need to be met in order for an enforcement order to be available to an enforcing authority. Importantly, point 1, when it comes to community infringements as defined under the Act, the trader must have engaged, be engaging, or be likely to engage in the infringing conduct. So we're looking at past, present, and future conduct. However, for domestic infringement, it's only has engaged or is engaging. So future conduct is not available for domestic infringements. And that's one of the slight quirks of the drafting of the legislation, a potential pitfall that can crop up. So there's no power to seek an order if it's a domestic infringement where the trader is likely to engage in it. As to what constitutes conduct, well, the number and nature of the incidents may be relevant to whether they will continue unless action is taken, but a single incident may still suffice. What's important, though, is it cannot be solely confined to the contractual relationship between a particular trader and a particular consumer. It must be in the collective interests of consumers. So point number 2 on the slide, harm to collective interests. Again, this is an overarching principle. In the case of the OFT and MB Design Scotland, which was a Scottish case, Lord Drummond Young expressed this concept as interests which are not a mere accumulation of the interests of individuals to whom harm has been caused by an infringement. He said there must be a harm or risk of harm to the public more generally, and that it's concerned not with contractual rights of individual consumers, but general trading standards. And then finally, there must have been a consultation which failed to bring about the cessation of the infringement. And it's important to remember that the consultation period starts after the investigation. And it's important to define when that consultation begins. There may have been communication with the trader which will not be part of the consultation. And it's also important to remember that the consultation must be aimed at cessation of the infringement. It can't just be a formality. The Enterprise Act 2002, brackets, Part 8 Request for Consultation, Order 2003, sets out the procedure that should be followed and the matters which should be dealt with in a consultation in advance of proceedings. Now, in some cases, consultation may be dispensed with, and you need the permission of the CMA to do that. There must be, in those cases, a clear and immediate danger of serious consumer harm, followed by a prompt application to the court. Now, whether you consult or whether it's been waived, you're no longer obliged to consult with the CMA before making the application, but you must still notify them. And once you've notified the CMA, you have to wait 7 days if you're planning on making an interim application, or 14 days before making an application for a full enforcement order. Interim applications can be made before or after the issue of proceedings for the full order, but if they are made, they must be made in accordance with Part 23 of the CPR, and that includes the notice provisions and also the service of schedules of costs. An important difference that's been made from the provisions of the Consumer Rights Act 2015 is that local weights and measures authorities can now seek orders outside of their area as a result of the provisions of Part 6 of Schedule 5 of the CRA. So authorities are now no longer confined to seeking enforcement orders within their own area. So we'll go to slide 2 now, and we're now dealing with issues related to actually issuing the proceedings and starting the claim. This is an area where sometimes problems have arisen. So you want to make sure that you get all of the technical and procedural aspects of this correct. As this is a civil claim, it started by issuing a claim form at court and paying the issue fee. Proceedings can be issued in the High Court or in the County Court. Generally, you'll issue in the High Court for more serious infringements, the County Court for less serious infringements. Once you've issued the claim form, you then have to serve it on the defendant. You can either serve the claim form on its own and then serve your particulars of claim later, or you can serve the particulars of claim and the claim form all together. Now, in this case, the claimant is going to be a local authority, which is a corporate body. And so the issue of who signs the particulars of claim in the claim form is important. You must make sure the person who signs those documents is a person who has authority to sign them because they're verified by a statement of truth. And if the wrong person signs a particulars of claim, then that can be a contempt of court. And that applies to anything verified by a statement of truth apart from a witness statement. So if in doubt, consult the civil procedure rules. Generally, a legal advisor will have standing to sign. The other thing to remember is that you're not confined to bring the claim against the company or against an individual. If the infringement is carried out by a company, you can bring the claim against both the company and the directors, and often this is a useful thing to do, because if you bring a claim against the company alone and you obtain an enforcement order, what you may find is that the company can be wound up and the director can carry on trading under a different company, and he personally will no longer be bound by the terms of that order unless it was against him as well. Finally, there are two ways that you can issue a claim in the civil courts, either under Part 7 of the CPR or Part 8. In the main, claims of this sort will be issued under Part 7 because there's likely to be a substantial dispute of fact. Issuing under Part 8 will only really come into play if there aren't actually any disputes over the facts of the case, but rather about the legal characterisation of those facts. Part 8 is a slightly different procedure. It also means that you won't be able to avail yourselves of some of the advantages of the Part 7 procedure. For example, if the defendant does not serve a defence in time under Part 7, you can apply for default judgment. That's not available to you under Part 8. So generally, Part 7 is going to be the way to proceed. So we'll turn to slide 3 now, and we will have a look at what you're hoping to achieve by way of resolution in the proceedings. And you can see that there are 3 outcomes that you might be aiming for. Undertakings to the enforcer can be accepted actually without issuing proceedings. So it may be the case that as part of the consultation process, undertakings are offered by the trader, and you might choose to accept those undertakings. Undertakings to the court and enforcement orders are made in the context of proceedings. An undertaking to the court is a promise to the court, and breach of that undertaking can amount to a contempt of court and is enforceable just as an enforcement order is enforceable. Generally, in civil proceedings, injunctions need to be carefully and precisely drafted in order to ensure that the defendant knows what he must refrain from doing, and that a breach can be established if required, particularly as there are penal consequences. However, in the case of Vance Miller, Lady Justice Arden considered that some generality in Part 8 injunctions is permitted. Now, in saying this, she considered the comments of Lord Drummond Young in the SB Designs case, which you remember is a Scottish case, and there he'd said that a considerable degree of generality is permitted. And an Arden LJ overtly diverged from that point of view. So it would seem in England, or in England and Wales, more precision is required than would be in Scotland, although still less than in injunctions generally. And you'll see from the slide it's also important to endorse any order with a penal notice so that you can enforce it as a contempt of court and seek committal in the event of breach. Now, one of the things that the CRA has amended in the Part 8 procedure is there is now the ability to include enhanced consumer measures in a Part 8 enforcement order. Again, that's been enforced since October 2015. There are three categories: redress, compliance, and choice. And these are positive obligations on the trader, which are designed to assist the collective interests of consumers in each of those three categories. The redress category is precisely what it sounds like: redress to any consumers who've suffered a loss as a result of the trader's actions. It's only available where consumers have suffered a loss. It won't be in every case that they have. You'll remember that this is a case about preventing future conduct which is against the collective interests of consumers. And if there is a case in which you have been told by a consumer or a number of consumers about a trader's conduct, but they've said that they understood fully that it was wrong and that they didn't hand over any money, there may still be a need to injunct future behaviour, although no loss to any actual consumers in the case. Secondly, compliance. This is about ensuring that there are no future breaches of the legislation. Examples of these measures might include appointing a compliance officer, introducing a complaints handling process, or improving record keeping. The choice category is designed to ensure that consumers have information available to them to be able to make better choices about who to use for their needs, and better information about the compliance history of traders that they are proposing to engage. So again, things in the choice category might include signing up to an established consumer review site, publicising details of the breach and what they've done to put the situation right, putting out statements in the press or on social media. And again, as long as those measures are proportionate, they can be included in the order as well. So looking at slide 5, we'll turn to the issue now of enforcement, because it's no good getting an order if you can't do anything about a breach. Well, first of all, a breach of an enforcement order or an undertaking to the court is a contempt of court. For that, the trader can be fined or can be committed to prison for up to 2 years. Now, it's important to note that this is a committal, a civil committal for contempt, not a criminal sentence. And unlike a criminal sentence, contempt can be purged. And so the point of committal to prison, in general, is to enforce compliance. So if the trader from prison somehow makes arrangements to remedy the breach of the order, he can apply to be released early. So it's not a sentence in the ordinary course of things. Now, if what was made by the court was short of a full enforcement order, such as an undertaking to the court or an interim enforcement order, proceedings on breach can also allow the court to impose any order they could have imposed otherwise. So a breach of an undertaking to the court can be transferred into a full enforcement order. Another key change that's been made to the enforcement provisions by the Consumer Rights Act is Section 220, subsection 2 of the Enterprise Act now provides for extraterritorial enforcement. So any local weights and measures authority can enforce any order, even if they were not the weights and measures authority which first made the order. So that, combined with Schedule 6, has widened the scope greatly of the territorial provisions in relation to enforcement. So local weights and measures authorities can now not only enforce against actions which have taken place outside of their area, but they can also enforce for breach orders which were made originally by a different authority. And finally, when undertaking any enforcement action, if you are not the CMA, you must notify the CMA of any applications which were made and also any orders which were made by the court as a result of those applications. Well, that's a very brief run through some of the procedural and evidential issues relating to the use of enforcement orders. I understand that we've had quite a few questions come through on the email, Robin.
Yes, in fact we have. The first question comes from Mohammed in Hampshire, and he asks, can an enforcement order taken out by one local authority be enforced by another local authority, or can it only be enforced by the original local authority that obtained the enforcement order?
Well, the answer to that is yes. Section 220, subsection 2 of the Enterprise Act, inserted by the Consumer Rights Act, now provides that any local weights and measures authority has the power to enforce any order as it was made by another authority. So any authority to enforce by the original local weights and measures authority is now exercisable by a different authority.
The next question is, in my experience, officers can often get dragged into a cycle of continually giving businesses a chance to comply with the law before finally trying to go to court. Do you have any advice on how to avoid this?
Well, I think the important thing is you've got to decide when you draw the line, and when you decide that the consultation process is not going to be able to achieve cessation of the infringement, because that's the test. If you consult and it looks like that consultation might have achieved cessation of the infringement, and you go to court to try to get the order, it would be very easy for the trader to say that that part of the test isn't met because they haven't had a chance to cease the infringement through the consultation process. However, that's not to say that you have to take every single assurance by a trader that they will cease the infringement at face value. Consultation is a part of the enforcement process, and if compliance is achieved through consultation alone, then it may be there's no need for proceedings at all. But if the breach happens again, and the trader gives assurances again, then the Trading Standards Department will have to consider whether to accept those assurances in light of the previous breach of the previous assurances. And so you needn't get stuck in a cycle of continuously accepting assurances only to be disappointed, because it may be that on the basis of previous actions, you find that those assurances would not actually be kept. And in those circumstances, you probably would be able to say that the consultation would not lead to the cessation of the order, because even though assurances are offered on this occasion, they've been breached on the last occasion or the last two occasions, and so now it's time to go to court. The key question is going to be whether any undertakings or informal assurances you're offered by the trader are worth anything in light of the particular facts and history of the case.
The next question is there any problem with audibly recording consultation meetings, like PACE interviews?
Not really, no. There's nothing preventing you from overtly recording a consultation meeting. There may be issues about how the recordings are stored and provided to the defendant, though. In a PACE interview, you're using very specialised equipment. The tapes are sealed, and there are all sorts of evidential safeguards to make sure that if they're ever relied on in court, there can be no issue about them being doctored or tampered with or failing in some way. If you wanted to do that in a consultation meeting, you'd have to make sure that you had some form of safeguard in those terms as well. It may be that having a consultation meeting in the room you normally use for a PACE interview wouldn't set the right tone in that kind of case. So you can do it, but in terms of making sure that there is an agreed and accurate record of what happened, it's possibly just as easy and just as useful to simply write after the meeting the very next day saying, we had this meeting, here's what was said, here's the action I said I would take, or here's the action you said you would take, and including a paragraph saying, if you disagree with what I have said in this letter, or if you think that I've misrepresented or misunderstood anything that was said, please let me know. And in those circumstances, you will have an agreed record in writing of what took place at the meeting. So I don't think there's anything that would stop you from recording a meeting. You just have to make sure that you have some way of being able to ensure that recording is kept properly and to protect yourself against any allegations by the trader of any misrepresentation or editing of the tape.
Next question. We've got quite a few to get through, Michael. Where criminal offences have been committed and Enterprise Act action is looked at as an alternative to prosecution, it is now becoming more common for enforcers to obtain criminal behaviour orders post-prosecution instead, usually against rogue trader types. I have seen wide orders such as not to cold call anywhere in the country. Could these be looked at as an alternative to Enterprise Act action in certain circumstances, i.e., when you want to prevent certain types of behaviour? It is not clear what type of restrictions you can apply with criminal behaviour orders. Can you advise?
Well, the important distinction between a Part 8 enforcement order and a criminal behaviour order is that the criminal behaviour order is only available post-conviction. So it's only going to be available in cases where the case actually meets the test for prosecution to begin with. So if there is not sufficient evidence to reach the criminal standard, but there is for the civil standard, or if it's not in the public interest to prosecute, but it is in the public interest to use a lesser form of enforcement like Part 8, then you won't be able to prosecute and you won't be able to use a criminal behaviour order. So first and foremost, you need to decide whether civil or criminal enforcement is the appropriate form of action in relation to the particular infringement. And it's a good idea to look at your local authority's enforcement policy for guidance on that as well. Now, the test for criminal behaviour orders is also that the trader or the defendant must have caused harassment, alarm or distress by his behaviour. Now, those terms, harassment, alarm and distress, are defined in case law, and they're very high thresholds, but they're also defined in the context of public order law. They're also terms which are personal. They deal with how a particular defendant has made a particular complainant feel, whereas the Enterprise Act deals with collective interests. So it's possible that cases which do meet the test for Enterprise Act enforcement would not fit easily into the CBO framework because while there may have been harm to collective interests of consumers, there hasn't been any harassment, alarm or distress caused to a particular consumer or group of consumers. It may be that it's appropriate in cases where there have been aggressive commercial practices, for example, but in most cases I would suggest going with Part 8 rather than trying to shoehorn what's really a Part 8 infringement into a criminal behaviour order. That said, if it is a case which meets the test of prosecution and where a criminal enforcement is appropriate, and it is a case where the kind of activities you're seeking to restrain do meet the tests of harassment, alarm or distress, then it may be a useful ancillary order to apply for in a criminal case.
Right, well, the next question from Emma in Gwent is, if you receive intelligence about a trader who is engaging in behaviour which breaches legislation covered by the Enterprise Act, and you visit that trader and find that yes, there are things wrong there, is it best to put the words consultation in the heading of your advisory letter, explaining what it means and so on? Or would you advise sending an advisory letter first to see if that brings compliance without mention of consultation?
Well, it's important to note that if you're planning to deal with something informally, that may well not be consultation under the Enterprise Act. You may decide before you proceed to consider the Enterprise Act, you'll give the trader a chance to deal with things on an informal basis. That said, once you have decided you are going to engage in consultation, you need to make sure that the trader is aware of that. And so once consultation is underway, I would certainly head any letters with consultation, Part 8, Enterprise Act, make it clear that the consultation now is being carried out for the purposes of deciding how to proceed and whether to proceed under the Enterprise Act with a view to gaining an enforcement order. So you may well say we're now consulting on use of the Enterprise Act. You may well, in the end, not issue proceedings. You may decide to accept an undertaking instead. But you must be clear when consultation starts, if that's distinct from some other form of advice or communication that you've had with the trader. And that's just because it will make it much clearer if any points are being taken about a failure to consult or a failure to wait the appropriate amount of time at the end of consultation. If you can point at when you started consultation or when you finished consultation, then it just makes things much cleaner and much clearer when you're applying that test in front of the court.
And the next question, if you are prosecuting a company and wish to also use the Enterprise Act as well, are you also required to engage in consultation? How does that process work using the two forms of enforcement together? Also, on the back of this question, if you prosecute and obtain an undertaking as well, can you also use the ECMs, or would you look at the prosecution as the punishment and the undertaking as a way of securing future compliance?
Yeah, the two jurisdictions will go in parallel. There is nothing in theory preventing civil enforcement and criminal enforcement being done at the same time. You're quite right to say that the point of Part 8 is to ensure future compliance, and the point of a prosecution is to punish past acts if they've been sufficiently serious to warrant criminal enforcement. So they do deal with two different sides of the relevant activity. But if you are going to proceed on the Part 8, you do still have to consult. The two will run in parallel. It may be that certain communications you have might play a role in both the consultation process and the criminal investigation, but you must be clear and not conflate the two. So you must be clear what action you're taking in the Enterprise Act and what action you're taking in the criminal investigation. And also consider, in terms of the amount of manpower it's going to use and costs, whether a case is right for concurrent enforcement like that. I've had relatively few cases which I thought were. It's not something that people ask very often. It is something I've been asked. But you've got to consider whether, for example, if the criminal offence is going to be so serious that the trader might be imprisoned for a substantial period of time, you may not consider that it's worth getting an enforcement order because his activities in trading would be so disrupted by the prison sentence that would be disproportionate to the amount of time and work you'd be putting in the civil courts. And so consider the facts of the case, but yes, the criminal and the civil routes would run in parallel, and they each have their own protocols that need to be complied with.
We've had another question that's come in that I think I might
Yes,
field, if that's all right, Michael.
By all means.
It has been said that Enterprise Act orders are a bit easier to obtain as we can use questionnaires as opposed to statements to quickly gather evidence from consumers, particularly those that live far away. However, in my personal experience of a civil court, they were very harsh on allowing hearsay evidence in. If we were to obtain 30 questionnaires for a case, is there a risk that a judge could refuse the evidence as it is hearsay? Would we be reliant on the hearsay evidence being allowed in to progress the case, i.e. at the mercy of the judge, or is there a way that we can insist? And if we do use questionnaire evidence, is there a minimum standard we should obtain, i.e. do they need a wet signature, or will an online form be acceptable? Does it need a statement of truth, and so on? I think, in general, the civil courts are actually much more relaxed when it comes to hearsay evidence than criminal courts. The issue may be that these questionnaires on their own in previous proceedings weren't submitted alongside a CPR compliant witness statement. So the correct procedure, I think, would usually be for the investigating officer to write a witness statement with a statement of truth and so on, exhibiting a number of these statements, saying, I collected these statements at these dates and from these people and the methods in which they were collected and so on, and then exhibiting them. If it's done in that way, I don't think there should be a problem.
I think the only thing I'd add to that as well is that while hearsay deals with questions of admissibility, you'd also want to consider the amount of weight which might be attached to evidence like that as well. And if it's a case where the factual allegations are going to be hard fought by the trader, it may be worth getting a full witness statement from the consumer in question, or at least the officer in question, rather than just the questionnaire.
And we've had another question that's come in from Tim using the live chat. The question is, can an informal undertaking be publicised?
Yes, undertakings are, as a matter of course, are published on the website of the enforcing authority, whether they're undertakings to the enforcer or undertakings to the court. The particular provision escapes me for that, unfortunately, but yes, the undertakings are public.
Well, I think that is all the time we have for questions. Of course, we here at Gough Square Chambers are always happy to help if you have any other questions or need advice in this area. Please tune in next time. We'll be broadcasting again on the 30th of November. That's a Thursday at 11 o'clock, when Kevin DeHaan QC and Bradley Say will be discussing gambling regulation.
So for now, it's goodbye from me.
And goodbye from me. Thank you very much.
Thank you.